beneficial professor of law at Harvard, served as Solicitor General for 4 years. For 4 years was on the Supreme Judicial Court of Massachusetts as an Associate Justice. Undergraduate degree from Princeton, law degree from Columbia, bachelor and master's from Oxford, an extraordinary academic and professional record. Professor Freed,
pretty good.
if the witnesses could move in and out, well, I'd appreciate it. Professor Reed, we're going to start your time now because we're running very close.
Thank you very much, Mr. Chairman. It is a great privilege to be allowed to participate in this historic hearing for such an important event. And it's particularly a privilege because I've been watching these hearings, and I must say they have been a model of intelligence, fairness, substantiveness, and civility.
Thank you.
I warmly support Judge Roberts because I am persuaded he knows the difference between law and politics. I think that not because I know him well, I hardly know him at all, but because I have studied his judicial writings. Politics, at its best, as this distinguished group of senators knows, is the art of recognizing and doing the best you can for the people you are responsible for. The judge does his or her best too, but the judge is hemmed in by the law. Not in any simple-minded way, not in any mechanical way, by the intent of the framers only, by the text of the statute only. And Judge Roberts does not believe that. He has told you so, and in his opinions he has written so. But by precedent, by the words of the statutes, but also by legislative history, by tradition, and the craft of the law. Judge Roberts seems to understand this down to his shoes, understand it with grace and humanity. My former boss, Dick Thornburg, stole a number of my lines because I too wanted to read to you that first paragraph from the Hedgepath opinion because it shows a man who not only has a head but a heart. But the other thing it showed was that though he has a heart as well as a head, he understood that if he were to say that what happened there violated the Constitution, he would be unfaithful to Supreme Court precedent, which he was bound to adhere to, and in fact, he would have been really worse than unfaithful to it. The other thing which he might have thought is, well, this is a terrible result. He said that it was a terrible result, and I can get away with it because the case is probably too trivial for the Supreme Court to take on review. But that is not the man who you are passing on today. In that opinion, you see his authentic voice and character. As I read and hear some of the criticisms of Judge Roberts' judging, I wonder whether we are talking about the same man. I wonder whether the critics are not really complaining that Judge Roberts didn't start with the result, their result, and then wrestle the law around until it fitted. That is not the man you are passing on. And when I think of some of the cases which he decided, which have become controversial in these hearings, not just the French fry case, but of course the hapless toad case as well, which Professor Belia will be talking about. When you consider his decision about arbitration under the Federal Arbitration Act, where there is a congressional act mandating that there be a preference for arbitration. When I consider the opinion which he did not write, but which he joined in the Hamden case, what I see is a fidelity to law, not the pursuit of an agenda. Thank you.
Thank you very much, Professor Freed. We turn now to Professor Peter Edelman from the Georgetown Law School, where he has been since 1982. He took leave from 1993 to worked in President Clinton's administration as counselor to Health and Human Services Secretary Donna Shalala and as Assistant Secretary for Planning and Evaluation. He had worked as legislative counsel for Senator Robert Kennedy. He clerked for Supreme Court Justice Arthur Goldberg and Henry Friendly of the U.S. Court of Appeals. Our background, Professor Edelman, thank you for coming in today, and the floor is yours.
Thank you, Mr. Chairman. I'm very pleased to be here and I appreciate the opportunity to testify and join Professor Freed in complimenting the committee as a citizen on the civility of these proceedings and the way in which there's an opportunity to educate our country. I think after that we probably disagree. I am here to urge that this nomination of Judge Roberts be rejected. The history of the decisions interpreting our Constitution is one that over the 2+ centuries is one of greatly increasing protection for the rights and liberties of our people. The evolution in the meaning of the open-ended language has meant more respect for individual rights and liberties against governmental overreaching, and at the same time more power for Congress to act to protect people against exploitation and injury by special interests. And as many witnesses have said, this has all made a great difference in the lives of millions of Americans, the two witnesses on the previous panel. So who sits on the court matters really crucially for all of us. And as Senator Biden talked about the record as one criterion before the earlier panel, Senator Kyle talked about best evidence, and I think that the best evidence we have here is really a long record over a long period of time, unlike some nominees that come before this committee, not just his judicial record. To me, and I did start out looking into this and doing the reading without a particular view other than knowing Judge Roberts' reputation as a very intelligent and able lawyer and as a conservative. But what I've concluded is really that it adds up to a troubling likelihood that we have here a nominee who is Chief Justice is really going to try to turn the clock back on this pattern of protection that I talked about. And it's not about one particular case that might be overruled. As to any one case, as important as it is, it's difficult to figure out what he might do. It's really about his judicial philosophy across the board in a whole lot of areas. It's how he views the Constitution as a whole. And it's where that will take him in particular cases in many different kinds of questions. He says a lot of the memos from the early 80s were a young staff lawyer done at the behest of his superiors. I think he's too modest. Because you look at that and over again, those are memoranda that often he wrote on his own initiative or in response to a question, recommendations for action were requested. There's no decision already made, and he was at the right fringe of even his conservative colleagues in the Reagan administration. And so that's the issue here, and this is a kind of a pure case about the direction that a nominee is going to take. There's no question about his intelligence, his ability as a lawyer, his integrity, his character. Those are not an issue. The issue is one of a conservatism that I think really radically threatens the meaning of the Constitution as we know it. He said the other day that judging's like being an umpire, just calling balls and strikes, and I'm not one for adding to the pile of sports analogies here. But you know, if the umpire stands 2 steps to the right behind the catcher, strikes are going to look like balls and many balls are going to look like strikes. And so I think the analogy is remarkably disingenuous. Constitutional interpretation is not like calling balls and strikes. Why do we have 5-4 decisions? These are matters of first impression where the precedent is to be looked at, but they're there because the decision has not been made on the issue. And so what we're here is trying to compare these strong differences of view that exist, 5-4, about the meaning of the text, because that's the heart of it, the intention of the framers, and all the other relevant history and societal values. And so it's subtle and complex, and there's a deep division and debate, and that's why this nomination is so important. We're really looking at a question of what our Constitution is all about, and we're looking about whether it's about fundamental principles of protection of individual rights and liberties, or really a much more cramped and crabbed view of those things. And you know, we've changed over the course of a century. The cramped view was where we were 100 years ago, and I'm afraid from looking at the record here that as a Chief Justice, Judge Roberts is going to work to take us back in time. Many of you remember the hearings. We all remember the hearings on Judge Bork's nomination. He made things easy for the committee. He put it all in one article in the Indiana Law Journal. There it was, and the committee could decide, the Senate could decide. Judge Roberts is what I call Bork by accretion, bit by bit. Memo by memo, speech by speech, and now opinion by opinion. And I think what it adds up to is far more radically conservative than Judge Bork. And so if you go through the list of issues, Senator Kennedy, you asked him about a series of civil rights issues, others have asked about other matters. When you add them all up, I think you have a pattern in each of these areas: civil rights, civil liberties, access to justice, a whole series of things, and then the pattern adds up to a pattern. And so that is why I'm here really to testify, because I think that what the pattern adds up to is a dangerous recipe for our nation, one that may result in injury and renewed vulnerability for literally millions of Americans who fought for decades and even centuries to be included in our constitutional promises. So I do urge the committee and the Senate to reject this nomination. Thank you for the chance to testify.
Breaking protocol just a little, Professor Edelman. Do you really think Judge Bork made it easy for the committee?
I think
you don't have to answer that question. You have a right.
Appreciate the comment, Senator, Mr. Chairman.
Our next witness is Professor Patricia Belia from Notre Dame, an extraordinary academic record, summa cum laude from Harvard, a Yale Law School graduate, clerk for Justice O'Connor, and before that, Judge Cabranes of the Second Circuit. Thank you for coming in today, Professor Belia, and we look forward to your testimony.
Thank you, Mr. Chairman, and other distinguished members of this committee. It's an honor for me to appear before you in support of the President's nomination of Judge John Roberts to be Chief Justice of the United States. I've never worked with Judge Roberts. Indeed, I've never met him. But during my time in Washington as a law clerk and as a lawyer in the Justice Department, I've had the privilege to know his work as an advocate before the Supreme Court. More recently, in my teaching and research in constitutional law and other areas, I've come to know his work as a judge in the U.S. Court of Appeals for the D.C. Circuit. In my view, the best evidence of how a nominee will perform as a judge is how he has performed as a judge. I've read all of the opinions that Judge Roberts has written in his time on the D.C. Circuit. His service on that court demonstrates beyond doubt that he resolves cases with competence, care, and fair-mindedness. Most importantly, his jurisprudence on the Court of Appeals demonstrates in decided fashion that Judge Roberts does not seek in his decisions to advance any platform of any current political ideology. He has joined in written opinions upholding claims of criminal defendants and joined in written opinions denying such claims. He's both accepted and rejected challenges to executive agency action claimed to be unlawful. He's interpreted statutes with great care, with a primary focus on the text that Congress has enacted, but never categorically dismissing any evidence that's probative of congressional intent. His opinions, be they for the court or for himself, display no rancor. Rather, they're notable for the respect and care with which they outline any disagreement he might have with the positions of litigants or his colleagues on the court. Nor do his opinions betray any impatience for the claims of any class of litigants. The occasional hints of exasperation in Judge Roberts' opinions are reserved for the district court judge or the administrative agency that's decided upon the rights and claims of individuals without providing the considered explanation to which he believes all persons who find themselves before our tribunals are entitled. It's therefore no surprise to find in Judge Roberts' opinions an extensive and careful scrutiny of the individual claims that each case squarely presents, no more and no less. There's not the time here for me to analyze each opinion that Judge Roberts has written on the Court of Appeals. And my written testimony examines in detail two areas of structural constitutional law in which Judge Roberts' work has been subject to criticism, the first involving questions of congressional power, and the second involving questions of executive power, particularly in foreign affairs. Here I'll simply allude to the first of those controversies and explain briefly why I believe that the criticisms were unfounded. A claim has been made that Judge Roberts takes an unduly narrow view of Congress's power under the Commerce Clause, one that endangers a variety of civil rights statutes and environmental regulations that Congress has justly designed to protect the equal rights of all Americans in the environment in which we live. This concern stems from Judge Roberts' opinion in a case called Rancho Viejo versus Norton, the hapless toad case. In that case, a housing developer, after losing a Commerce Clause challenge to a particular application of the Federal Endangered Species Act, sought rehearing of its claim before the full Court of Appeals. The active members of the D.C. Circuit declined to rehear the case, and Judge Roberts dissented from that denial of rehearing. It's important to establish precisely what Judge Roberts' dissent says and what it does not say. The dissent does not show that Judge Roberts believed the Endangered Species Act to be unconstitutional as applied in this case or as applied in any other case. Rather, he believed that the particular methodology that the court employed in deciding the case was out of step with Supreme Court doctrine. He took care to point out that en banc review would afford the court the opportunity to consider alternative grounds for sustaining application of the Act that may be more consistent with Supreme Court precedent. Rather than demonstrating a hostility to congressional power, the dissent demonstrates a concern that courts provide the right reasons for their decisions. That concern is, of course, well-founded, as the reasons that courts provide in support of their decisions are central to the corpus of law that will guide judicial action in subsequent cases. A discussion of single opinion in isolation certainly cannot capture the depth and care and respect for every litigant that Judge Roberts' opinions display, and I'd welcome the opportunity to discuss other aspects of Judge Roberts' opinions in response to your questions. But I believe that his jurisprudence on the Court of Appeals reflects the best of what we can and should expect of a nominee to the Supreme Court of the United States. His decisions defy categorization as conservative or liberal, Republican or Democrat. Indeed, Judge Roberts himself has refused to characterize himself as subscribing to any particular judicial philosophy. He says that he simply decides every case as it comes before him according to the law, as best he can discern it. What he has accomplished thus far in the Court of Appeals demonstrates that he's truthfully represented himself to the American public. Simply put, he's demonstrated that he possesses one of our nation's foremost legal minds, that he employs that mind with full fairness and integrity, and in all of this, that he well deserves our trust to lead our nation's judiciary. Thank you.
Thank you very much, Professor Belia. Thank you for being so close to time. 3 seconds yielded back. Our next witness is Professor Judith Resnick, the Arthur Lyman Professor of Law at Yale. Interesting to see that they have a chair for Arthur Lyman, who was in law school when I was there. She teaches on the feminist theory, gender procedure, co-chair of the Women's Faculty Forum, a member of the Ninth Circuit Gender Bias Task Force. That's quite a title. And co-author of the monograph, Effects of Gender. Thank you very much for coming again, Professor Resnick, and we look forward to your testimony.
Thank you. I'm honored to participate, and I've submitted a written statement for the record. In these 5 minutes...
He made a part of the record in full.
Thank you. I'm going to make 5 fast points. First, while I'm here because I was invited by this committee, we are all here in this room with a TV because the Constitution has invited us all. The Constitution has committed to the political branches of the United States the decision about who shall be our life-tenured judges. The President nominates, the Senate confirms. We're part of a national teach-in about America, its values, and what the courts stand for. In recent years, the confirmation process has been criticized. Some have been difficult. But conflict is not an artifact of these cameras or of the conflicts over Bork and Thomas. It goes back hundreds of years. Remember that in the 1790s, the Senate did not affirm the Chief Justice because they disagreed with John Rutledge's view of a treaty with England. In the 19th century, it was a debate about railroads and unions. We've seen time and again that we debate our values through this process. So in other words, this hearing is not only about John Roberts, it's about us, Americans, what we care about for our system of justice. Point one. Point two, this is no ordinary hearing, even though it's about a life-tenured appointment to the United States Supreme Court. This is about who's going to be the Chief Justice of the United States, the 17th person in our entire history to hold that position. The job of the Chief has not remained static. It's grown enormously over the 20th century. As a law professor of the federal courts and of adjudication and civil procedure, we get to credit William Howard Taft and most recently the extraordinary work of William Rehnquist. The person who wears the robe of the Chief Justice, striped or basic black, doesn't only wear one hat, but many hats. Senator Kennedy, Senator Thurmond talked about this person as the major symbol of justice in the United States. More than that, this person has enormous power over the administration of justice in the United States. In addition to being the head of the United States Supreme Court, this person is the CEO, the Chief Executive Officer of the entire federal judicial system. 1,200 life-tenured judges, a budget of more than $4 billion, a staff of more than 30,000, working in 750 courthouses around the United States, hearing hundreds of thousands of cases every year for all of us. The Chief is the head of the policy-making body for the federal judiciary. The Chief picks about 50 judges who sit on specialized courts, dealing from foreign surveillance to product liability. The Chief picks 250 people to serve on the committees that make the rules that we all litigate by in the federal system. The Chief sets the agenda for the federal courts through its annual State of the Judiciary address. Now, this repertoire of powers is startling and actually anomalous, out of sync for a democracy. Unlike what judges do in court, working openly, giving decisions accountable, transparent, the administrative powers are not easily seen, probably not even known to lots of people. Further, unlike most administrators, the Chief has that power, at least under current practices, for life. The President has term limits. You all have to run. Even administrators move on. Not so under current practice. Now, this package of power is not constitutionally mandated. The Constitution only mentions the Chief once, and it's in terms of the impeachment of the President. So given that this is the rare occasion upon which we think about the Chief Justice, I would be remiss not to mention that there's a chance that we could rethink the issue of the Chief Justice rotating 4-, 5-year, 6-year terms. Quick recap. Point one, an opportunity to reflect on American values, take our constitutional temperature. Point two, an extraordinary appointment, the unique roles of the Chief. Point three, therefore, this is the occasion to figure out what the qualifications and requirements for the Chief are, which gets me to my answer, point four. The Chief Justice of the United States should be the chief advocate for justice in the United States, should be the person insistent on access to the courts, clear that courts are vital. The Chief Justice should be committed to an independent and vibrant branch of government called the third branch. The Chief Justice should come here telling you, the Congress, that it needs more resources, needs more access, should be the guardian at the gate of justice. We need the Chief to be sure that the President, the Executive, respects the independence of adjudication and that the Congress does as well. Most important, we need a Chief Justice who understands that law has to be a source of strength for those who don't have it, who need it. Not only a source of strength for those who already have the resources, who can already get easily into court. Those are the litmus tests of where we can all be proud. My fifth and final point. What does the nominee's record tell us thus far? I've reviewed only written materials from 81 to 86 when he was a policy-making lawyer and signing them in his own name, only decisions on the D.C. Circuit, only published essays and transcripts, nothing from the SG's office, nothing from private practice, because we can't know what his own personal views are. I regret to report that at least as of this set of materials, Judge Roberts has not expressed an affirmative vision, a deep enthusiasm for the role of courts for adjudication, for the needs that courts fill for ordinary Americans. When given the opportunity to argue for courts for their accessibility, when given the opportunity to argue the Department of Justice should lend its hand to the needy Americans in need of more resources, when given the opportunity to interpret statutes to let us into court, that in general, the nominee has argued against the use of courts. There have been some shorthand in these hearings for some of those decisions. I feel obliged to mention at least one other. There's a case called Booker, which is about a problem all of us face, where the courthouse door is closing on us because we have cell phones and credit cards that mandate we go to arbitration. There's an equal access to justice case. There are several others. There are many instances in the record in which, at least thus far, the nominee
Resnick,
has
would
not.
you summarize your
I'm just
testimony,
closing
please?
right now. What we're looking for in the Chief Justice is a person who will celebrate courts and the role they play in a vital, economically stable democracy. And that is the question before the Senate. Is this person's record the one to commend this person for that job? Thank you.
Thank you very much, Professor Resnick. Our next witness is Professor Christopher Yu, professor at Vanderbilt University Law School, a distinguished academic record, a graduate of Harvard, MBA at the Anderson School at UCLA, Northwestern Law School, clerked for Justice Kennedy, and practiced with Hogan and Hartson. Thank you very much for coming in, Professor Yu, and the floor is yours, 5 minutes.
Thank you, Mr. Chairman, members of the committee. It is an honor to be here to testify in support of John Roberts' nomination as Chief Justice of the United States. I've had the chance to observe Judge Roberts from 3 different vantage points. First, as an associate working in the appellate group of Hogan and Hartson. Second, as a law clerk watching Judge Roberts argue before the Supreme Court of the United States. And third, as a member of the faculty of the Vanderbilt University Law School reading his judicial opinions. Because there are many other colleagues here who are in a position to testify to his excellence as an appellate advocate and to his performance on the Court of Appeals, I will focus my remarks on the time Judge Roberts and I spent at Hogan and Hartson. I'm sure Senator Biden will be gratified to hear that during his time at Hogan and Hartson, John Roberts demonstrated to me an open-mindedness and ability to bring people together that would serve him well as Chief Justice. He also treated everyone around him with respect and decency. I had the chance to witness these qualities firsthand in the support and compassion that he showed to me when a tragedy struck my family. Judge Roberts' open-mindedness is evident in his decision to join Hogan and Hartson when leaving the White House counsel's office in 1986. Hogan has long prided itself on its ability to embrace attorneys from across the political spectrum. To cite just 2 prominent examples, its ranks include former House Minority Leader Bob Michel and such leading Democrats as former Chairman of the House Subcommittee of Health and the Environment, Paul Rogers. It is also a firm that takes seriously the bar's obligation to provide free legal services to public interest organizations and to individuals who are unable to afford them. Judge Roberts was exceptionally well-liked throughout the firm. His regular lunch partners reflected the underlying diversity of the firm itself. Even more telling is his decision to return to Hogan after his successful stint as Principal Deputy Solicitor General. At a time when firms were lining up for the chance to hire him, including firms that attract those who wish to surround themselves with like-minded colleagues, Judge Roberts preferred to return to a more balanced and politically diverse environment. Judge Roberts' open-mindedness can also be seen in the manner in which he developed Hogan's appellate practice. Although the practice group was never large, the attorneys he hired reflected the diversity of the entire firm. Indeed, I suspect that he takes considerable pride in the fact that nearly half of the associates brought into the appellate group under his leadership were women, and that the women with whom he worked most closely on Supreme Court and appellate matters are now partners in the appellate group. He also represented a broad range of clients with diverse and even conflicting ideologies, without requiring that every client's position match his own personal views. His reputation for fairness and willingness to engage all viewpoints were so well established that Democratic attorney generals and governors did not hesitate to hire him to represent their interests. In the process, he successfully advocated positions on behalf of clients on environmental protection and race-conscious remedies that did not match what many might regard as the standard conservative position on those issues. The pattern of fairness and open-mindedness that is apparent in his professional decisions is consistent with my own experiences working with Judge Roberts. He brought the same probing intellect and rigorous professionalism to every aspect of each case, searching through every possible viewpoint in the process of deciding how best to approach it. Simply put, Judge Roberts' tenure at Hogan and Hartson suggests a person who is fair and who is willing to engage and consider all points of view before making up his mind. My other memory of Judge Roberts from our time together at Hogan is the respect with which he treated everyone around him, from senior partners to secretaries and paralegals to law students who were only working at the firm for a summer. He was always supportive and encouraging, even while holding us to the highest professional standards. He also never forgot the personal side of the people who worked for him. I had the chance to see this aspect of Judge Roberts' character firsthand shortly after I rejoined the firm after my Supreme Court clerkship. I was working full bore on a slate of cases. My father-in-law had just arrived in the D.C. area to celebrate the recent birth of my second son, Brendan. Shortly after my father-in-law arrived, he was admitted to the intensive care unit of Arlington Hospital. After a 3.5-month battle for his life, he eventually died. Judge Roberts reacted the way we wish everyone would. The minute he found out about my father-in-law's illness, he offered his sympathy and support. He rearranged my assignments to make it possible for me to make my family my first priority. He often checked in on me, always with a thoughtful gesture and a kind word. And when my father-in-law passed away, he released me from all of my assignments on a moment's notice, placed me on paid leave of absence so I could take care of my family when it needed me, even though I was facing a number of deadlines, and doing so would mean taking on considerable work himself. When I returned, he welcomed me back with open arms, without a single word about the problems caused by the abruptness of my departure. For John Roberts, it was all very simple. It was just the right thing to do. At the same time, Judge Roberts has a humility that is somewhat surprising in someone so accomplished.
Professor Yu, would you please summarize at this point?
In short, I'm convinced that John Roberts possesses the open-mindedness, compassion, and humility that the Senate seeks in the members of our nation's highest court. He combines these qualities with a respect for the law and for the Supreme Court as an institution that leave no doubt in my mind that he would make an admirable Chief Justice.
Thank you, Professor Yu. That was a good transition to ask you to summarize, to go right to, and quote, in short, unquote. Our next witness and final in this panel is Professor David Strauss, an extraordinary academic background, a member of the magna cum laude Harvard Law School Club. Not too many of you. Judge Roberts is one. 2 years at Oxford, attorney advisor in the Carter Justice Department. Worked on the Judiciary Committee here, a special counsel during the Justice Souter nomination proceedings, and has been at the University of Chicago for some time, 18 cases before the Supreme Court. You're on, Professor Strauss.
Thank you very much, Mr. Chairman, members of the committee. It's an honor to appear before you. My purpose here is really not to pass judgment on John Roberts, someone I admire very much in many ways, but rather to speak about a development in the subject I teach and study, constitutional law, something that's happened in that area in the last generation that is very significant and directly relevant to this hearing and to the judicial appointments process generally. And that development is a change in the nature of judicial conservatism. You can see the change if you look at what President Nixon said when he appointed Justice Rehnquist, and what President Bush, who of course has nominated Justice Rehnquist's successor, has said. President Nixon said he wanted to appoint a judicial conservative, and he identified his model. His model was Justice Harlan. President Bush, of course, has identified his models, and his models are Justice Scalia and Justice Thomas. All of these people are judicial conservatives, but there is a world of difference between the two different kinds of conservatism. The hallmarks of Justice Harlan's work were deference to Congress and respect for precedent. The hallmarks of the new conservatism is something close to the opposite of that, a skeptical attitude toward the work of Congress and a willingness to overturn precedent. And it is really that difference, not the difference between liberals and conservatives, but the difference between these two different kinds of conservatism that make the stakes in the judicial appointments process very high at this point in our history. I identified a number of areas in my written remarks where I think the stakes are high. Let me just mention two here. The first is Congress's power to address the problems facing the American people and to protect the rights of the American people. I think it is fair to say that the power of Congress to do those things is under challenge in the judiciary today in a way it has not been since before the Great Depression. And this is true not just in the case of the now famous Toad, but in area after area, and many of which the hearings have discussed. In the area of environmental protection, workplace safety, consumer protection, campaign finance, the rights of the disabled, as we heard, the free exercise of religion, age discrimination, gender discrimination, the protection of intellectual property rights. In all of those areas, there are significant efforts underway in the judiciary to limit in important ways the power of Congress to do what it has been doing now for the better part of a century, protecting the rights and serving the needs of the American people. The other area is, of course, the right of privacy. The right of privacy, the modern right of privacy, was essentially an invention of Justice Harlan, the judicial conservative that President Nixon cited as a model when he appointed Justice Rehnquist. It was an opinion Justice Harlan wrote that was the font of privacy law that is extended not just in the case of abortion, but in many other areas, not just in the case of reproductive rights, but in many other areas today. Justice Harlan took a view of privacy that rested on a generous and expansive reading of American traditions. He did not expect people claiming rights to point to some specific tradition or some specific body of law. He understood that the questions were more difficult than that. The right of privacy now, if anything, is more important, indeed much more important than it was when Justice Harlan wrote, with changes in reproductive technology and end-of-life technologies that make these questions all the more acute. And the question whether we will have a Justice Harlan-like approach to the right of privacy or a skeptical approach to the right of privacy that questions whether it even exists and evinces a desire to confine it as narrowly as possible, that question, it seems to me, is very much on the table and will be a question that will be with us for the next generation. I don't want to be alarmist about this. The law doesn't change overnight. These are not changes that will occur, maybe not even with this appointment. But there are points in the history of the Supreme Court. The New Deal was one. The Civil Rights Revolution was one. There are points in the history of the Supreme Court where the court rethinks and redefines its relationship to the other branches of government and its relationship to the rights of individuals. We may be at such a point. There are indications that we are at such a point. We have not passed it yet, but the next few appointments to the Supreme Court will determine whether this is an era in which the Supreme Court redefines its relationship in a way that is basically unknown to Americans living today. Those are the stakes presented by this appointment and by other appointments that this committee will face. Thank you very much, Mr. Chairman.
Well, thank you very much, Professor Strauss, for those profound comments. This is an extraordinary panel which could yield a lot of fruits with a lot of questioning, except that we have 6 more witnesses and it's almost 6 o'clock. I'm going to start by yielding to Senator Feinstein.
I have no questions. Thank you, Mr. Chairman.
I'm glad I yielded to you, Senator Feinstein. Senator Sessions.
Mr. Freed, it's an honor to have you with us. I was as a member of the Department of Justice when you served as Solicitor General, and you represent the best in American law, and I'm pleased to see you at Harvard and teaching students what American law is all about. I noticed that the legal publications have declared that Judge Roberts may be is the premier appellate court practitioner in America in a generation. You've argued before the Supreme Court. I don't think you're personal friends with Judge Roberts, but from your observations, how do you rank him as a scholar and as a practitioner in the Supreme Court?
As a practitioner, he's the best. As a scholar, he doesn't exist. He doesn't purport to be a scholar. He hasn't written scholarly articles. That's not his business. And in that respect, he is very much like some of the greats. Earl Warren was not a scholar when he went on the court and had written no articles. Henry Friendly wrote all his articles after he became a judge. Similarly, I think with Benjamin Nathan Cardozo. So it does not denigrate Judge Roberts to say scholarly is not what he has done. Perhaps he shall, but he hasn't so far.
And with regard to his service on the court and his expressed philosophy of being a neutral umpire, one who decides the case before the court and not one to impose any personal or political views through his opinions, is that consistent in your opinion with the classical American tradition of law?
It's the best tradition, Senator, the very best tradition.
Would you agree with one witness at our hearing who said, if you believe and cherish your liberties are much safer with a judge who shows restraint than one who is an activist?
Well, I have never understood what that restraint activist contrast is meant to show, but I think my liberties are safest with a judge who will listen to the facts of my case, will listen to my lawyer's arguments, and will decide on the basis of them, rather than a judge who comes in with an agenda or with a predisposition or perhaps even with a philosophy.
And if they're faithful to the Constitution, in the long run, our liberties are protected in that fashion also, are they not?
The rule of law is our greatest protection, Senator.
Thank you, Mr. Chairman. Thank you for your service to your country and you sharing these thoughts with us today.
Thank you, Senator Sessions. Well, now that we've saved so much time, I'm going to take a few minutes on a question or two. Professor Resnick, you advance a fascinating suggestion that the Chief Justice's position might be rotated. Suggest that by an act of Congress?
There are many different
You would
possibilities.
expect them to make a deal among themselves.
Well, actually, because the role of the Chief Justice is a mixture of about dozens of statutes from this Congress episodically enacted and many customs, it would be possible for the court to develop a custom that would alter the allocation of authority.
How about an act of Congress? That's something we can do something about.
We
don't seem to have too much influence on the court, even with our confirmation process.
Congress has...
Because once confirmed, we never hear from them. They never call, they never write. Can Congress pass an act to rotate the Chief Justice job?
In my view and reading of the Constitution, yes, Congress has the authority to decide that the Chief Justiceship is a position that could be inhabited by one member of the court for a certain period of time and then by another. In addition,
would that be reviewable by the court?
Well, we believe that every statute can be considered for its constitutionality. So, of course, the court could consider it, and then the question would be...
They wouldn't have a conflict of interest?
Well, the court has actually developed a rule called the rule of necessity, which is to say that it says when everyone's disqualified, then no one's disqualified. There is actually a Supreme Court in Texas old decision in the 1920s that says when everyone's disqualified, we got to go find an extra ad hoc court for a moment. So there are differences depending on the state or federal system. But right now, the court would... in fact, as you know, the court has considered challenges that say that you have unfairly diminished their salary under Article 3, and the court has said we have to sit on those cases because here we are, and have decided sometimes yes and sometimes no under the Article 3 guarantee of no diminution of salary.
Have we been successful in diminishing their salary?
According to the court, there have been a couple instances of small
statutes. So we have a formula
statutes.
where we can do that constitutionally?
You have in your hat, as members of Congress, you can pass statutes that the court then reviews. You may not diminish their salary, but the close questions come up on things like if you are prospectively altering COLAs, cost of living increases, or you're changing the benefits or annuities. Those are the kinds of instances that come up. There have been a few class actions by some judges who are doing that, and as you know, the Chief Justice of the United States was here. Chief Justice Rehnquist was a wonderful advocate, greatly concerned about
Professor
the resources
Resnick, I want to stay
courts.
within 5 minutes, so I want to
Certainly.
move on, if I may. Professor Strauss, you gave a fascinating analysis, but you didn't tell us whether you're for or against Judge Roberts. Do you care to do that?
Actually, Senator, with all respect, I don't. I mean, There's
been another witness here who didn't answer questions. You have? some precedent.
I can't say this will come before me in another capacity, so I don't want to prejudge it. I don't want to. My expertise is in constitutional law. I feel comfortable talking about that. I don't want to claim the sort of familiarity with Judge Roberts' record. I haven't had the conversations with him the members of the committee have had, and I don't think it would serve a purpose to take sides.
I respect that. Professor Freed, I had read and wanted it confirmed, and I sent my chief counsel to confirm it, that you had written on the subject of Roe versus Wade that you thought it was wrongly decided, but that it would not be reversed. Did you take a position on whether it should be reversed, as well as the two propositions I articulated? Because they wouldn't be inconsistent to think it was wrongly decided and think that having lasted so long that it ought to stay.
I think it won't be reversed, and I don't think it should be reversed. Not only has it become...
Even though you were against the decision.
It was wrongly decided initially, as not only I, but Archibald Cox, Paul Freund, and Dean Ely thought. But it has become, as you say, a super precedent. And not only has it become...
Only super with 38 chances to reverse it?
Super duper, if you wish.
I do. Thank you very much. That's the first authentication I've had.
It's not only that it has been reaffirmed as to abortion, but that it has ramified, it has struck roots. So it has been cited and used in the Lawrence case, the homosexual sodomy case, in some of the opinions in the right to die cases, in the Troxel case, which is the grandparent visiting right case. So it's not only that it's there and it's a big tree, but it has ramified and exfoliated, and it would be an enormous disruption.
What?
So you not only get branches, you get leaves.
Exfoliate.
It's done all of that, and that means
I know what exfoliate means. I just didn't hear you.
And since I don't know Judge Roberts except most casually, and I certainly have never discussed it, if you want a prediction from me, I would predict that he would never vote, not never, but he would not vote to overrule it for the reasons that I've given.
Well, that's a topic of extensive discussion in the cloakrooms of the Senate and on the Senate floor and in the hallways. Senator Feinstein and I are talking about it, whether he would or would not, and there are clues, but no certainty. Well, I'm past time. I'd really like to engage in some more discussion, but I have duties to proceed. Senator DeWine has joined us. I'm confident this will be a no-question response, but I'll ask for questions. Senator DeWine?
Very short. Professor Resnick, I know you had some comments about the Chief Justice, and you had an exchange with the chairman in regard to the rotation of the Chief Justice. Just kind of a general question. Are you troubled in any way by the growing authority of the Chief Justice, or do you want to comment about that
yes,
at all?
and I write about the federal courts, and I've raised concerns about this because I think that this is too large a charter. Some of it coming back to the Senate the Congress has given in several statutes direct authority to the Chief Justice to appoint from life tenure judges to sit on courts. That does not have to be the way that judges are assigned. They could, for example, be assigned to specialized courts by taking all of the judges on the courts of appeals through some random rotation. So there's a
FISA court, for example, is appointed by the
There's a colleague, another law professor named Theodore Ruger at the University of Pennsylvania, who's analyzed the appointments on that court and has a law review article detailing it. He actually reports that the Chief Justice he's the one who has the count of about 50 appointments of other judges to specialized panels or courts. The Congress also could, for example, the Judicial Conference of the United States, which is the major policy-making body, that could be chaired by, again, a rotating group of Court of Appeals judges. The many committees that are being appointed, many other judiciaries around the world are dealing with this question. How do we provide all the justice we need to for all of our citizens, have it organized, be sure that there's a voice that comes to tell the world about its needs, and then not develop a kind of bureaucracy that means that that judges are losing their role as adjudicators as they seek to set agendas and set future agendas. And it's a hard problem that everyone is facing because we need lots of judges. So if you go back at the turn of the century, 1900s, fewer than 100 judges around the United States, life tenured. Fast forward, between magistrate and bankruptcy judges, we've got 2,000. They need organization, they need equipment, they need staffs. They need all these things, but at the same time, we also need to cherish the role of open, visible, accessible courts. And that's the challenge, and I think that the Congress and the courts could work together, as they have over the last century, to create this great system in rethinking the allocation of authority.
Very helpful. Thank you.
Thank you very much, Senator White. Thank you very much. You've been a very enlightening panel. Lots of brain power. 6 professors in a row. It's a tribute even to this hallowed room. Thank you. On to panel 6. Ms. Diana Turgot-Roth from the Hudson Institute, Secretary Reich, Rabbi Polikoff, etc. If you all take your seats. Our first witness is Ms. Diana Turgot-Roth, Senior Fellow and Director of the Hudson Centers for Employment Policy, had been the Chief Economist at the Department of